Hi there, welcome to Tech Talks. I'm Liz Hardie and I'm joined today by John Chew from the ICANN Technical Services team. We're doing a series of Tech Talks covering the questions that we were asked on our end of tax year planning webinar. As there were a lot of them, we've split them into a few separate sessions, and this one covers some of the questions that relate to the reforms bringing pensions into the IHT net. So to kick off, we were asked how pensions will impact IHT. And that's a really far-ranging question. And essentially, the inclusion of unused pension pots touches almost every aspect of IHT. HMRC estimates that around 38,500 estates will pay more IHT than before, and that about 10.5 additional estates will now become liable to IHT. So if we consider the nil rate band, for example, the proposals in the consultation mean that any unused pensions will use a proportion of that nil rate band. So where clients' other assets might have had all of the nil rate band left after the house was taken into account, for example, from 2027, the unused pension pot will also eat into that. So it's more likely that the client's other assets will become subject to IHT. John, would you like to have some input as to what else might be considered?
Yes, thank you, Liz. I think this is kind of very much a moving object at the moment. So fundamentally, one of the things that we need to consider about is how this will be applied, i.e. the process. So the important thing we need to consider as part of all of that is we start to think about, well, do our clients have a number of different pensions? And this could be a situation where we might be thinking about trying to consolidate a number of pension pots into a single one, because when we start to think about the process itself, it is quite complex. And bear in mind, we will be expecting personal representatives at a time when things could be quite challenging for clients to actually go through quite a formal process in a very short period of time. So just to quickly kind of outline the process for you. In essence, when a person passes away, you have 6 months from the end of that month of death in order to complete this process. This process is not really straightforward. In essence, what you will need to do is break down the individual's estate into, I guess, the assets which are non-pension and those which are pension. And of course, that could be multiple pots. And in each of that calculations, you then need to proportion the amount of the pension, for example, against that of the full estate. And once you've then established that proportion, you then need to apply that proportion to the amount of available nil rate band. And the reason you need to do all of this is because ultimately what you have to do is that the personal rep will need to communicate with the provider in order to establish the value of the pension pot, and there lies a few problems in their own right, to then tell the provider how much of the available nil rate band is appropriate for each of the different pension pots that you hold. So you can't, for example, allocate an appropriate just to one pension pot. It will have to go across all the available pension pots. Then inform and provide evidence to each of those providers. And of course, ultimately, they can then deduct the IHT that is due, pay that to HMRC, and then and only then can they release the money to the personal reps. Now, as I say, this needs to be all completed within 6 months. And of course, if you don't complete that in time, there will be an interest that will be accruing upon the unpaid debt, typically around about 4% above base, etc. So you can start to see this could be quite a complex piece of calculations that we're going to go to. Now, HMRC are going to be providing a calculator. What that calculator looks like, we don't know. So hopefully that will cover multiple pension pots. So as you can see, it's a very short window. You do require a lot of interaction with the providers, and obviously that poses some challenges if providers aren't able to value a fund, for example, in a SIP or SAS, where you might have, say, commercial property, because, of course, the date of death is the date of valuation. And if you have to pay money from a pension pot that is illiquid, you're going to have to sell the property, or you're going to have assets within the pot that can actually pay the IHT liability. So you can see lots of potential complications there, and of course issues for personal reps. And of course, the other side of this equation is once that IHT has been paid, the beneficiaries then of course inherit the pot. Now, of course, that then means that if they want to enjoy that pension pot, then of course they're going to be subject to income tax at their marginal rate. So there's a lot of press and a lot of discussions around, well, is this in effect, causing a double taxation on the fund? And as things look, that's probably the case. And of course, that then forms part of their inheritance tax problem, and so forth. The problem goes further and further on. So that's kind of an idea around that. There's a lot more detail around this. And again, our account managers have some further details that can be supplied to yourselves should you want more around that. So hopefully that kind of covers the question for you, Liz.
Mm-hmm. Yeah, thanks, John. So a lot of pressure on legal personal representatives, and a lot of extra admin for them to do. I mean, I know from my personal point of view, I've got 6 pensions, so that's a lot of pressure for my legal personal reps. Yeah.
Indeed.
So back to the sort of nil rate band side of it. In terms of the transferable nil rate band and residence nil rate band, your registered legal partner will still have that exemption. So post 2027, if a pension is transferred to a spouse, then that will still be exempt. But do bear in mind that this will then form part of the spouse's IHT estate, and that doesn't matter whether it's the deceased died pre-75 or post-75. Isn't that correct, John? Yeah.
Yeah, absolutely correct. Yeah, and again, there are lots of different strategies that we will need to consider, and certainly that this is the time to start engaging with clients to talk about what those potential changes are going to look like moving forward. Remember, this is a technical consultation that we've been through. So the process is not about really discussing the final outcome, it's how we actually administer the requirements of what's been set out. So again, it does mean that we need to have those conversations early. Whether this is the time to act or not, of course, is subject to individual client circumstances. But of course, engaging with a client a lot earlier in this process, then at very least they're going to be aware of what the potential options are open to them. And of course, that means that, we can explore those, which we'll be taking forward in the next set of podcasts.
Yeah. Okay. So I think that's probably a good place to maybe round this Tech Talks up. And we will see you in the next one. Thank you, John.
Thank you very much.